I will now turn to this IP public lecture, which fortunately I can give in English because I'm a bit more comfortable in English. This is what I want to cover on this evening. I mean, you've seen the topic, patent enforcement, and I hope that by the end of this evening I've made a strong point that granting a patent is not enough. You also have to provide for a way to enforce that patent, to get it on the road. And how that could be done in South Africa will be the end of this presentation, and I hope that afterwards we'll be able to engage in a small discussion, maybe here, maybe over finger food and drinks in the other garment. And because the topic I think is worth it, and therefore I was delighted that I had the chance to speak on patent enforcement here in Africa, that I have this chance today. These are my 4 points. I'm not going to throw a huge PowerPoint presentation on you. I basically have 5 slides. So that is it. For the most part, I just want us to sort of be on the same page and then, for the most part, talk freely without doing something as boring as reading slides to you. First point is why inventors seek patent protection, because it's good to remember why innovators are looking for patent protection in the first place. As you know, South Africa is moving towards an examination system, which it hasn't had before. The question is always, I mean, if you change something, why are you changing it, and what are your customers, in a sense, a patent office does have customers, what do they expect, and what do they need the patents for that you're offering? Second point is one that I'm afraid didn't make me too popular with the CIPC, because at the end of the day, creating a patent office is not the hard part. The hard part is to have good, meaning effective, and also efficient patent enforcement. There are many countries who have good patent offices, like China, for example, but in the diaspora, to provide patent courts where you can enforce these patents, that's the challenge. And then the question, sort of the natural next question is, what does it take to create effective patent courts? And then I'll come to the policy lessons, and then you are going to be rifled up. A common stereotype is that the patent system is for, one could say, the rich and the famous in the industry. The Siemenses, the Pfizers, the Fords, the Daimlers. And of course, these companies do use the patent system. But I want to give you 2 examples of companies startup companies that obtain patents for reasons quite different from those of big industry. And it is my thesis that it's these small companies, the SMEs, that need the system more than the fat cats, if you want. Now, my first case is Schnecksagen, which is an enterprise by a young woman who studied biology in the north of Germany. Many Bavarians would now say, yes, there is intelligent life there too. But she studied biology at the University of Kiel, which is on the Danish border. Her idea was, I mean, we all know what a nuisance snails can be in the garden. And her invention was, or her idea was, on which she then based an invention, was that if you basically painted, for example, a pot in which you planted something with a non-sticky, or gave it a non-sticky surface, the snails couldn't climb it. There are many ways. I mean, when you look at that up on the web, there are many promises how you can prevent losses of plants by snails, but hardly any work. And there are also these sort of house recipes that you have to use beer and track them and whatnot. None of that really works. But this does. And she was alone when she founded this company. Now, what problems do startup companies usually have? Their main problem is entrepreneurial finance. They need to get by the funds. They need to get by the money that you need to make your company grow. Because if you do not get by that money, you will, at the end, in the end, not always, but often die of starvation, because you just cannot expand. And because you don't have a lot of money, you're also threatened by powerful competitors who do have money. And there these fat cats come in. Now if you have a patent, all of that changes, because the patent enables you to get the venture capitalists, VCs, interested. Even banks love it when you have a patent, even though from a business standpoint, the patent doesn't even necessarily do much for you, because what a venture capitalist or a bank is interested in, must be interested in, is whether you will become profitable. No patent office can judge that. They're not claiming that. They're not equipped to do that. All they do is they check whether the substantive patentability requirements, mainly technicality, novelty, inventive step, and industrial applicability, in America you would say usefulness, whether these substantive patentability requirements are met. That's all. There are good inventions that fail, as there are good ideas that fail in the marketplace. When I used to work, in my attorney's practice back in the old days, legal history now, I had a client who was German but from Johannesburg. But he worked in Germany, South Africa. German passport, but basically South African. And he had thought up a system by means of which you could use your mobile telephone, smartphones didn't exist yet, to pay. And that idea did not get airborne, because people and banks and venture capitalists said, what is a mobile telephone for? They call it a telephone because you want to make telephone calls with it. Nobody wants to use it for banking. It's not safe. And have you ever, this was a time when even telephone banking was not really well established. So nobody was interested. From today's perspective, huge mistake, because all of us have a banking app on their smartphone, and all of us, almost all of us, entrust this banking app their banking transactions. But nevertheless, that was an innovation that didn't take off, even though it was a very good idea. It was a brilliant idea, but it nevertheless did not take off. Now, that you couldn't have patented because it wasn't technical enough. But Schnecksagon, this Schnecke is German for snail. It's not a very good name, but the stuff really is good and is successful. But in the beginning, it was just this one biologist, who actually didn't find a job, by the way, and so started her own company. And now she's really successful. And she has a patent. And the funny thing is that she told me, I've never really needed it. And I said, what do you mean? Well, she said, well, I never had to threaten someone with that patent and so on. But at the same time, she's admitting that she only got the funds she needed because she had that patent. So obviously, there are very different ways of using a patent. Of course, you can exclude others, because the bottom line of every patent is it's an exclusionary right. It's a right that enables you to keep the market clean if you want to. But its purposes go far beyond that. And I've sort of put them on this slide. You can use it for marketing yourselves. You can attract funds by means of showing that obviously the patent office thinks what you're doing is new, kind of original, What you're doing is inventive, so it's not not obvious, and what you're doing works, because that's what industrial applicability at the end of the day, for the most part, is that it works, that it's reproducible, and that it doesn't say anything about profitability, but usually venture capitalists think, or banks think, that they can judge profitability on their own. That's an assessment, that's an entrepreneurial decision. When you give somebody money and you think that they're going to, that they will use it in a good way. And even if you have a powerful competitor, a patent may be the reason why they want to buy you. Because if they can beat you, they may want to buy you. So many of our we have quite a startup scene in Munich. And many of our TUM startups, who usually are research associate PhD students, basically just at the launch lab that I had the pleasure to see a few days ago. Basically same thing. Some of them are basically some of these entrepreneurs, some of these startup founders are basically just waiting for a big company to come along, make them a good offer, and then sell it. Be bought out. Because they usually already have sort of another idea, what one could also do. And then they are going to take that money that they're being, the buyout money, so to speak, they're going to use that in order to realize the next idea, which is exactly what we want. But shows, and that's important, that a patent can do much more than just sort of threaten others. Even though everything hinges on the enforceability. Nobody needs a patent that just says patent. I mean, the P word as such is not going to do the deal. It must be enforceable. But nevertheless, let's sort of quickly work down that list. So for marketing, the patent is good. For survival, because if you are in a system like Germany, for example, when you get sued in Germany, if you win your case, you're entitled to all of your attorney's fees and court fees to be reimbursed. Section 91 of the German Code of Civil Procedure provides that, in a sense, the winner takes it all. In other words, the loser has to pay it all. So other than in the US, where you can sue and just by means of creating cost, try to bring pressure to bear on a smaller competitor, that is not possible. That is not possible in Germany. So that situation is kind of comfortable. In Germany, you can even insure the risk of being sued. So just threatening to sue someone, like prominent people in America are doing all the time, doesn't work in our system. Patents are also sort of for the long term, because patents grant a 20-year monopoly. This is the same in pretty much everywhere. Has to do with the Paris Convention. And of course, there are different ways to exploit a patent. You can create revenue by using it, you can sell it, you can license it, you can do many things with it. Universities, for example, sell or license. They never produce, hardly ever. I mean, here the situation is a bit different because what I sort of learned from what Innovus is doing, the Stellenbosch also will hold shares in companies that are being will hold shares in startup companies, you could say. Which, by the way, makes a university a non-producing entity. A term that I'm not very, a patent troll, you could say. One could say, because some people think that somebody who doesn't produce isn't a real patent holder, as if the patent system was about jobs, which it isn't. It's about a good idea that you share, that you contribute to the state of the art, and in return, the respective state, country provides you an exclusionary right for a time-limited exclusionary right. Okay, so patents are a versatile tool. That is my bottom line. Now, a few things about patent offices. To 2 days ago, I was in Johannesburg and I met with the CIPC, and the CIPC is creating a patent office for an examination system where you have to train examiners, where you have to recruit examiners, then train them and bring them up to speed is not easy, one must say. Especially if you don't have, like even the German office, that is part of the European Patent Organization, but the German office as a national office still has 1,000 examiners. And of course, integrating like 100 new ones is easier if you already have 1,000 that will help to train the new ones than if you are basically starting it from scratch. And the South African examination system, not the patent system, but the examination system, really is something that didn't exist in this country before. So that is quite a task, one must say. On the other hand, there are a few genuine advantages that patent offices have all over the world. First of all, they usually are located in the nation's capitals. Germany is an exception for historical reasons, quite a story by the way, but and I'm happy to share that with you in the discussion, but it's, so in Germany, the patent office is in, actually both patent offices, the European and the German one, are in Munich, whereas the nation's capital is in Berlin, as we know. But usually patent offices, like in this country, are in the nation's capital. Now what is the nice thing about that? The nice thing is that if you are in the capital, there is you meet people, you meet members of parliament, you can have, the president of the patent office, or the commissioner, however you want to call him or her, can have lunch with politicians and will be heard. It's easier to be heard if you are in the nation's capital and if you're part of this community that exists. All patent offices have that, Germany being an exception. German patent office, by the way, is an exception also in the way that it's part of the Department of Justice, of the Federal Ministry of Justice, Bundesjustizministerium, not of the Ministry of Trade and Industry, or the equivalent. That is also kind of unusual. But patent offices, therefore, all over the world, or that's one reason why patent offices are doing well all over the world. Another major reason, that doesn't have to do with the location, but another reason why they're doing well is that patent offices make money. They all make money. Patent offices are money machines. Just sort of a figure, the German office contributes to the German federal budget 150 million euros per year, every year. The European office, that gives a share of its fees to the European Patent Organization member states, Germany, because many applications come from Germany, contributes 250 million euros to the German federal budget. In other words, 400 million euros every year come from the patent system. That puts patent offices and presidents of patent offices in a very comfortable position, because they don't have to go somewhere and basically ask for money, which is not very pleasant, as we know from public universities, mine is one too. But they are basically sitting on a box of cash, which makes your life much easier. Now, patent offices, because they have this political access, also can prompt statutory legislation, basically. Can prompt legislation to, for example, round off their offering. If they can convince the legislature that having a utility model, as we would say, heavy patent, might be a good idea, they are in a position to lobby that in the nation's capital. And many countries have that. Utility models, by the way, some European countries have them, like Germany has them, Austria has them, but many countries don't. France doesn't have one. So, and that is also something that a patent office can do. I'm saying all this because it will, in order to show you that the situation of patent courts is much less comfortable. It's much harder to set up a good patent court system than it is to set up a decently working patent office. One of the things that patent offices, for example, can do, and that patent courts never can do, is they can outsource the examination if they want to. Singapore, for example, did that for years. They had first, I mean, in the Commonwealth, and probably same held true for South Africa decades ago. In the Commonwealth, it used to be that if you received a patent application, the patent application would be sent to London, to the British Patent Office. They would examine the application, then would send it back. And then you would grant the patent. So all the examination in the British Commonwealth was outsourced at that time, or had been outsourced to the British Patent Office. And Singapore, and that of course prevented the National Patent Office of the Commonwealth countries to establish examination departments and to have examiners, because these examiners would sit in London. Which is the reason why Singapore, when they stopped doing that, had to look for another place where they could send their patent applications for examination. So they used IP Australia. IP Australia is insourcing many examination jobs. There are patent offices, the Austrian office, for example, the Danish office, that sit in countries that wouldn't support an office of that size, but they're doing work for others. That is something that a patent office can do. So theoretically, if they wanted to, the South African office, for example, could, and I think they're doing that, could say, we are going to have examiners and we're going to focus on certain technologies. From what I know, the South African office wants to focus on pharmaceutical patents, because that is a pressing problem in South Africa. Whether pharma patents are the best way to start, I'm not so sure, because in when it comes to pharmaceutical innovation, you are facing companies that have more patent engineers and patent attorneys, far more, than you as an office have in examiners. So they are loaded with cash, and they are loaded with legal expertise, and they are not easy to handle. It's probably a political decision that because the pharma issue shall be fixed in South Africa, that the patent office must do it this way. Anyway, what you can do as a patent office, and that's something that a patent court cannot do, what you can do is you can, as I said, you can outsource, or you can use what is called patent prosecution highways. In other words, you can look at what other offices found with regard to the very same invention, because the patent system is still, for the most part, national. The European Patent Office is an exception, but otherwise you go to the USPTO if you want to go to the United States, and the USPTO cannot issue a patent for Japan or not even for Canada. And then you go to Canada, and then you go to not Canada. Then you go to, well, theoretically you could also go to Canada, but you usually don't, because it's one market in North America, so the Canadian office is basically being sort of pushed aside by the USPTO. But, for example, telecommunications industry, it's one system. You cannot use a technology just in Canada. It will be used in the United States, so you will infringe upon an American patent, which is why IT companies don't patent in Canada. They just patent the US fine. But the US office also cannot issue a patent for Japan, say, or for South Africa. But you have to go to South Africa if you want protection here. And if you go to South Africa, that does not give you protection in, say, Mozambique, or in Zimbabwe, or in Namibia. You have to go to the respective countries. I'm not quite sure how the situation is with Namibia, but I'm pretty sure that you have to get protection there if you want it. And when it comes to pharmaceuticals, you may want it, because pharma is expensive, and usually pharmaceutical companies roll out patent carpets in all the countries where they're marketing their drugs. So there will be other patent office. There will be findings from other patent offices. examination results. Other offices will have examined the same application. And there now are so-called patent prosecution highways. In other words, offices rely upon examination results of other offices. Like the German office, for example, has such a patent prosecution highway with the JPO, the Japanese office. And if the Japanese office does an examination, we know it's going to be well done, and we'll just take it over, basically. Saves a lot of money. So there are ways for patent offices to make their lives easier. For patent courts, that is much harder. Too. By the way, one last thing about patent offices. I often mention the EPO, which is the European Patent Organization, and in English also the European Patent Office. It's a bit misunderstanding. In German it's easier. It's Europäische Patentorganisation, which the Afrikaans speakers will understand. And it's also Europäisches Patentamt, the European Patent Office. So it's EPA for the office and EPO for the organization. That's kind of a little easier, whereas in English it's EPO in both cases, and only the context reveals what is meant. The interesting thing is that even though there is the European Patent Office, all countries have kept their patent offices. Why? Because the European patent basically is an examination process for sort of one centralized examination process, but then the patents are registered in the national offices, and annuities, the annual fees to keep the patent alive, have to be paid to these national offices. And why are they doing that? Because it's profitable. Because patent offices make most of their money by means of these annuities, of the annual fees that need to be paid to keep the patent alive. These are rising towards the end of the patent term. That much as regards patent offices. Now let's turn to enforcement. My starting point is that a patent in the beginning is an investment for the inventor. If you're a startup company, and many startups think about that, the question for you is, do you want to spend the money on obtaining a patent? It's not cheap. And the cost is less with the offices. It's more with the patent attorneys drafting the patent application, and with patent attorneys translating applications into other languages. Why? Because that is serious work. A patent attorney needs to understand what the whole thing is about. He needs to put that into a kind of a technical, legal technical sort of language. It's not easy to describe a technical an invention in a way that enables a court to say, to determine the scope of the patent in a reliable way. It's harder than you think. And translations in that, if you go to Mozambique, for example, you would have to have a Portuguese translation. And you cannot, if you sort of happen to know a student from Brazil, you can ask him to translate a patent application just because he knows Portuguese. But that needs to be somebody who knows how technical Portuguese, what technical Portuguese must sound like and be for this invention, so that it's as accurate as it is in English in this country, for example. Assuming that most South African patent applications will be filed in English. They probably can also be filed in Afrikaans, but that's for fans like me. In the patent scene is probably going to be English for the most part, because the English application you will be able to use elsewhere. There are many countries where English is an official language. But if you need, again, if you want to go to Mozambique, you have to have, or to Angola, you have to have a Portuguese translation. That translation, and having a patent application translated into another language is serious work, and also is expensive, because you need an expert to do it, and experts are just expensive. Now, the interesting thing is that patents that patent offices, by the way, do not make money. I'm saying this because I'll get back to it sort of a little further down the road. Patent offices do not make money on examinations. They actually lose money. Examinations are too cheap, you can say. Because if an examiner works for like 1.5 or 2 days, and they're not more productive than that, if they want to be thorough, it's a simple calculation. That is, of course, cost. And the fees are not covering that cost. A patent breaks even for the office. My guess is, nobody knows, of course, offices do know the numbers, but they're not telling. My guess is somewhere between years 6 and 8, if this patent stays in force, is when a patent office breaks even. At the end of the day, it's going to make a profit if the patent stays alive all these 20 years. But definitely a patent office is going to lose money on an application that it rejects, which is a problem, because it might provide incentive to say, we get the inventor off our back because he gets what he wants. We make some money. Why care? That's the wrong approach, but there is, of course, sort of a certain temptation. Anyway, for the inventor, launching a patent application is cost. And we're talking, in Europe, we are talking, if you go to the European office, 5-digit euros. Medium 5, depending on how many countries you are going to validate the patent in. But if it's 5 countries there, which would be the average number, then it's going to be a 5-digit euro amount. And for a startup company, that's a lot of money. So it's an entrepreneurial decision already whether you want to obtain a patent, yes or no. And because the patent as such, or let me rephrase that, because the patent as such doesn't help you, it's just a piece of paper where a patent office says we're granting you a patent. You only can do something with it if basically it embodies a credible threat that it might be enforced. Only then is the patent going to be respected, and only then is it going to help the inventor, who will want exactly that. So everything hinges, and this is a sentence I am going to read because it's so important. So everything hinges on whether the right granted, the patent, can be effectively enforced. From a user perspective. So this is something that patent courts need to deliver. From a public policy perspective, patent courts have a few other functions as well. They must rule on nullity actions, because there must be a way to retroactively annul a patent that has been granted even though it shouldn't have been granted. This happens because if you, again, German office receives 70,000 patent applications annually. 200 per day. And, every day, not just work day. So every hour, roughly sort of 10 applications come in. That's a lot. And and of course, if you examine 70,000 applications, there will be a few foul apples in the basket. You can say that again. Yes, it's not foul eggs, it's foul apples. But you know what I mean. There will be a few that should not have been granted. Inevitably. Those you must get rid of. So the system needs to be equipped, and only courts can do that, that even after years, the register can be cleansed from these patents that shouldn't have been granted. And nullity actions are a tool by means of which that can be done. You can also have an appeal to the patent office, but you need to have a mechanism where patents can be put up for review even if they have been granted. Otherwise, there is no way to cleanse the register. and it would be unrealistic. Even if the examination was very good, it would be totally unrealistic to think that there weren't any mistakes. So that is, from a public policy standpoint, a task for a patent. Then there must be something like compulsory licenses, because there can be situations when, for example, a medical drug, I'm deliberately choosing this example here, when for example, HIV needs to be effectively contained and people basically healed. If that was possible, then you cannot deny people treatment just because there is a patent if people are dying on a large scale. I mean, from a public policy standpoint, unacceptable. So that too cannot be decided by, in a sense, that can amount to an expropriation. I'm not going to go into this. But that can amount to an expropriation. And so that needs to, there must be a way to have this reviewed by a court. So patent courts need to fulfill this function as well. And when it comes to standard essential patents, where a patent all of a sudden not only controls a technology, but a market, those two need to be licensed under FRAND standards, fair, reasonable, and non-discriminatory are these licenses. Now, what is fair and reasonable is an interesting question, because the calculation of these licensing fees is something that you can still write a PhD thesis on. But that, at the end of the day, also will be something for a patent court. So patent courts have many tasks, and setting them up is not so easy. Now, what you basically need in all of these cases is basically three features. And in the discussion, for example, about the unitary patent and the unified patent court system, in other words, the EU patent that is being discussed right now, there are realists like me who think unlikely that it's going to come. There are optimists or idealists who think that it's just around the corner. Hinges on the Brexit to some degree, whether that is really going to happen. And basically, patent courts, as in a sense all courts, need to perform or need to meet three challenges. First of all, they need to be competent, of course. I mean, the verdicts that come out must be accepted by the parties. I mean, saying that they must be correct is kind of a little too easy. I mean, because when is a verdict correct? I would say, also from my experience as a career judge, different system than this than what you have, but nevertheless, a good verdict is a verdict that both attorneys can explain to their clients, and because the court says why they have come to this result. And even though nobody's thrilled when they're losing a case in court, the reasoning, I mean, corporate clients are not babies. So they will not be thrilled, but they will, if it's a well-reasoned decision, they will understand, and their attorneys will be able to communicate to them why the court decided in that way, and that there is a point. In my three-year Mannheim practice, I never saw a case where the parties or the attorneys, I mean, these are usually corporate parties, so it's not a sort of neighbors conflict or something. So it's really not emotional. Attorneys are pleading in a very, I mean, if it got loud, the court would be annoyed, and we would signal that we expected a little more professionalism. And we would basically have sort of a discussion of legal issues, which is nice. But which also led to the result that parties usually were accepting what we ruled. I mean, especially after I left, I could have I would still meet these attorneys at conferences and pretty much all the time. I mean, the patent scene is not small in Germany, but it's also not so big that you only meet once. You always meet again, not just twice. And sort of after, say, 7 years or something, they could have told me, you know what, that decision really is fair. And you didn't get that. Quite to the contrary. I had a number of cases where there was nothing in it for sort of the trial lawyers, where they said, at the time, I mean, I of course had to take the other side, but it's not a bad decision. And we could explain it to our client. That is as good as it gets in a sense. That I've found, sort of, for me, those were sort of the highlights of my, I found that satisfying as a judge. And when the parties would say, your reasoning, sort of, to some degree convincing, we would have preferred a different outcome, but we could, in a sense, live with it because we saw that you had sort of understood the problem and the issue that sort of at the end made the difference. You could decide your way. And that is basically what I'm meaning when I say sort of competence, that judges exhaust the legal problems of a case and then find solutions that the parties accept. On that level, it is, I think, helpful if courts explain what they're doing. French courts don't do that, for example. French courts rule. Lex imperat non docet. The law rules, it doesn't teach, is the basic idea of French law and French courts. And they are very short in their decisions. They find that elegant when they just say, in a sort of brutally precise way, that is our ruling. End of story. German courts refer to jurisprudence, for example, and of course to other, and they give a lot of, they cite to other decisions, to literature, and so on. I think that is a good idea, not because I'm German, but because I think that it makes it easier for the parties to understand why the court found this decision and not another one. So that's the quality aspect. And how do you reach that? At the end of the day, you need to have a critical number of cases, not a subcritical small number, but enough cases. And I'll get to that in a few minutes. Speed, of course, is important. The effective patent life is 15, 16, 14 years, depending on how long it took for the patent to take effect. So not that long. And therefore, it's important for parties to get a result quickly. In MAM, our target was first instance 6 to 8 months, which is very fast. And that's what, of course, parties want. Because businesses want to move ahead, so they want to leave that behind them and then turn to other things. So that's an issue. I mean, that's one of the big problems of the Italian system, for example. In Italy, it takes between 4 and 7 years until you have a first instance verdict. That is too long, and that's what basically is driving parties in Europe away from Italy. Italy has few cases because the parties don't want that. And then there is cost. I mean, cost can kill. In the United States, that is, you can observe that. American trials are extremely expensive. English trials, by the way, also are expensive. English trials are about 2.5 times as expensive as German trials. And so cost, of course, is a factor, as is reimbursement. Problem is, these are all civil procedure. This is all civil procedure. It's not patent law. So getting a handle on all of this is part of the problems of setting up a patent court system. It's easier, as I said, it's easier to set up a patent office than a system of patent courts. So we have quality, one could say speed and cost, and that is relevant, and the relevance of this you can observe in Europe. In Europe, roughly 1,000 patent infringement cases are going down every year. More than 70% of these cases are being tried in Germany. Number 2 is France. Number 3 is the Netherlands. Number 4 is Britain. Even though British courts are excellent, I mean, the quality is not the problem. The problem with British courts is cost. So only very well-off plaintiffs go to London, pharmaceutical industry. They go to London. And this is definitely not a quality thing. It's a cost thing, because corporate clients in the patent world are cost conscious. So fora compete, and they do compete because often in the corporate world, parties strike an agreement that they say, okay, we're going to litigate this through in Germany, and what is going to be decided there, we are going to observe for other jurisdictions as well, so that we don't have to meet in 20 jurisdictions, which is driving the cost. This also is something that I want you to remember when I sort of later come to South Africa. Bifurcation, do you want to distinguish between patent infringements and patent validity, sort of have a validity track and have an infringement track, as Germany has, as Korea has, as Japan used to have, but they abolished it? That also is an interesting question that I'm not going to go into right now because of time constraints. Now, these are the policy lessons. First of all, one must realize that South Africa does not yet get a state-of-the-art patent system if it has a decent patent office. This country also needs, and it doesn't have to be decent patent courts, it can be a centralized court in wherever you want, Cape Town, Pretoria, Bloemfontein. But it does need patent courts, and these courts do not fall from the sky. But if South Africa wanted that, it would be easy to recruit and to train able judges. South Africa used to have patent judges. They retired, from what I know, they retired, so right now the sort of expertise is sort of enjoying retirement, but it's not rocket science. I mean, it's something that of course, you need to have a healthy relationship with technology. You need to understand what sort of a patent that is being litigated in front of you is all about, and what claim construction is, and so on. But that can be learned, and it will not be a problem. The training will not be a problem. There are enough countries, and they wouldn't even have to be from the Northern Hemisphere. They could also be from Australia, for example, that training could be done. That is not a big problem. Another good news is that as patent offices, also patent courts make money. Why? Because patent cases always are high-value cases. So, this is what I wanted to show you. German patent courts contribute profit. I mean, this is not revenue; it's profit. 20 to 30 million to their respective states, because courts are state courts, and only the top level, the Federal Court of Justice, is a federal court. Normally, regional courts or higher regional courts in Germany are state courts. So these fees are go to the respective state. But again, patent courts do not cost money. They make money. because they don't have small cases where on which they're hardly any, on which they're losing money. The cases that sort of I saw in Mannheim, almost all were 7-digit. Starts with $1 million. I mean, sometimes you have one or the other that only has like 600,000 euros. But usually it's $1 million upwards. I mean, and some really sort of huge numbers. When Apple sues Motorola, they're suing for 5 billion euros, for example. Just as in this IP world, there's big money being moved. So that is not something that, the investment will not be the problem, because you're basically setting up a system that is going to make money. Here are the numbers sort of for Germany, just that you see sort of the countries are in Germany, altogether close to 1,000 cases. It's so I chose the wrong number. Altogether in Europe, it's more like 1,300. Roughly in Düsseldorf, it's close to 500. In Mannheim, it's a little over 200. In Munich, it's a little less. And the rest, which also is interesting, all these other courts, there are 15 courts in Germany that have jurisdiction for patent methods. And only the business is between 3, maybe 5. But if you want to sort of integrate, say, Frankfurt and Hamburg, but it's, for the most part, it's 3 courts. Now, this is something that I want to make you interested in. South Africa, for historical reasons of apartheid, never assumed the leading role that the country as a technology hub with a functional judicature could have assumed. The Aribo headquarters, which is the patent organization of the English-speaking countries, is in Harare, and WAFI, the French-speaking, of course, wouldn't go to South Africa, but they're not in South Africa. This now could be changed. When it comes to a patent court system, that could be changed, because all African countries have a huge problem with enforcement. There are not many countries where the court in the southern African peninsula, where courts are without problems. I mean, in no countries courts are without problems, but we all know what I'm talking about. And these problems do not exist certainly not to that degree, but the South African judicature, from what I know and have heard, and I can tell you the reputation that it has. Now you can correct me if I'm wrong, but the South African judicature has a very good reputation in Europe, for example. In a sense, Europeans will say that's a country you can go to and sue there. You will get a good verdict, and you will not have problems that you have in many countries in the Southern African Peninsula. Now, if this is so, in other words, if Southern African countries, while having patent offices, do have an enforcement problem, why not conclude agreements with them on a national level that you will try their cases? I mean, wouldn't even have to be without their participation. I mean, why not have them send a judge, for example, that could be made part of a supranational sort of court, like the Unitary Patent Court in Europe that is being considered. Invite, say, Namibia for starters. That's an easy part. Invite Zimbabwe. I mean, all these countries must know that nobody's going to go there to obtain a patent if they can't enforce it. But if the patent enforcement, I mean, this would mean that the patent then would be tried patent infringement would be tried in South Africa. And of course these countries, but that would be part of the agreement, would then have to recognize the ruling, so that the verdict then could be enforced in the respective countries. If that, and I don't even think that that would be so difficult, because it doesn't cost money. It is going to the system is going to be self-sufficient. It's probably even going to create a little profit that would go back to the country, would enormously help with the marketing of such an idea. If you'd say there is basically no real cost. Even the and even the training could be done without a lot of cost. I mean, for example, the European Patent Office is sitting on more than a box of cash, and they're doing all kinds of training exercises right now with the CIPC, because the European Office, just as the WIPO, the World Intellectual Property Organization in Geneva, are fascinated that South Africa is basically revamping its patent system. But the Patent Office is not enough. It also needs a good patent court, basically a system, two instances, like a sort of trial court and the Court of Appeals. But roughly, I mean, according to the South African system, you don't even need as many judges as we need, because you don't have, on the trial court level, I think you don't have panels, do you? I mean, one even could have. If it was supposed to be a system, a transnational system, you probably should have. Because then you could, say, have a panel of 3, and if the case came from, say, Namibia, one of the panel, one judge would be Namibian. And if the case came from Zimbabwe, one member of the panel could be Zimbabwean, just for the sort of sake of the argument. And I think that this would be a great chance for South Africa to assume a leading position in an area where it always, sort of in a sense, was the hidden leader, but wasn't accepted by its surrounding. And that's what I would like to see. And thinking about that would sort of discussing that in Pretoria, I think would be worth all our while.
But I think we don't want to keep the capers too long. But